Hello and good morning. Welcome to our live stream here today, or good afternoon, good evening, depending on where you are today. My name is Eric Kimberling, and this is our weekly live stream focused on digital transformation topics. It's a weekly live stream that presents a number of different guests that I interview to dive into some of the different nuances, different angles of digital transformation. This live stream that we're filming here today with you all will actually become part of the Transformation Ground Control podcast that gets released next week. So you're kind of seeing how the sausage is made here. You're part of the live production here, and we'll polish up this recording and make it part of the podcast that comes out next week. So before we get started, though, before I introduce our guest, just a couple of quick logistic things. First of all, thank you for being here. But second of all, if you have questions or anything you want to cover, please drop your comments in the chat at any point along the way. We'll take questions from the audience as we go. I've got some questions to get us started, but would love to get your feedback as we go here. And then secondly, if you could also just drop in the chat stream wherever you're joining from today. By the way, we're streaming to YouTube, LinkedIn, Facebook, Twitter, among other platforms. Be sure to drop in the chat where you're joining from today. Where in the world are you today? Just so we know where our global audience is and who we have here on the call here today. So that's the second thing. And then, of course, as I mentioned before, if you have any questions that you'd like to ask our guest, please jump in at any point. And today, our topic, before I introduce our guest, is focused on digital transformation, vendor contract, and legal strategies. And this is a guest that I've had on my podcast a couple of times. This will be, I think, the third time that he's been on my podcast. He's been part of our virtual and in-person digital stratosphere conference events that we host. And I'll tell you more about that as we go here. And by the way, if you're interested in that event, that is in February 8th through 10th. You can register at stratosphere2022.com. And that's a great event where Marcus Harris, myself, and then others that are not on the stream here today will be speaking at that event. So I encourage you, if you're going through digital transformation, trying to learn more about transformation, join that event at stratosphere2022.com. So all that being said, that's the topic for today: digital transformation, vendor contract, and legal strategies. What better way to do that rather than one who knows nothing about legal strategies or law, which is myself? I thought, why not invite a guest who knows a lot about this stuff on the show here today. So I wanted to invite to have Marcus Harris here today. So Marcus, thanks for being here today.
Well, thanks a lot for having me again, Eric. I really appreciate the opportunity, and I'm excited to share some of my knowledge from the legal side of these transactions with the audience today.
Absolutely, yeah. And that's kind of where we wanted to hone in here today, is sort of that upfront procurement and just the overall legal strategy, contract and legal strategies as it relates to not only procuring software and services up front, but also on an ongoing basis too. How do you manage to those contracts and mitigate risks, both from a legal and just more of a general implementation perspective? But before we jump into some of the questions I've got for you and whatever questions the audience has here, maybe just tell us a little bit about yourself. What have you done in your career, and where do you work? All that good stuff.
Yeah, I've got about 20 years of experience in this space. In when I say this space, what I mean specifically is drafting and negotiating, litigating ERP-related contracts and projects. So, anything from software development agreements, MSAs, consulting agreements, statements of work, licenses, SaaS agreements, cybersecurity, DPAs, all of that kind of is in that bundle. That's all related to the implementation, design, integration of large software systems for larger enterprises. And really, I focus on two areas. And the first one is, like I said, drafting and negotiating these types of agreements. So it's really getting in there with large clients, SAP, Infor, Oracle, going toe to toe in a drawn out negotiation process or a quick one. And then, God forbid this were to happen to any of the people listening today, but, a failed implementation project, taking that where it needs to be to get it resolved, whether that's mediation, arbitration, or, as you know, Eric, litigation, using all the skill sets that we have as lawyers to help our clients recover from the damages that they incur from a failed implementation project.
Sure. Yeah, and it's probably worth noting that's how you and I first met or know each other, is from past litigation involving vendors and system integrators, where you've hired me to be an expert witness for those cases. That's sort of how you and I first met as a client consultant relationship.
Yeah, that's exactly how it was, and it was an interesting case many years ago. And we continue to do that, have interesting cases, and tap you as necessary if there's an opportunity that makes sense.
Yeah, absolutely. So yeah, hopefully the audience here today doesn't ever need you for those services, but certainly if they do have a failure, they know who to reach out to, and that you can help. But kind of moving to the front end here of transformation and sort of setting the tone for a transformation. I guess just to set the context for some of the questions I'll ask you is, it seems like there's so many decisions and criteria and parameters that get defined from a legal perspective, but also just from a pure delivery and execution perspective up front during this whole contract, vendor contract procurement process. But I think a lot of organizations don't really know what to look for, what the risks are, what the pitfalls are. But it's so important because you're sort of baking in what the project is going to be. You're setting the trajectory, you're setting parameters for yourselves, for your vendors, all that stuff. And so maybe just to start, if you could, before I jump into my real questions, is maybe just explain to the audience, if you don't mind, like why is this so important, this whole upfront piece of vendor contracts, procurement, all that stuff.
Yeah, well, I think you touched on it. Really what you're doing through the contract negotiation process and putting the contract in place is you're really setting the tone for how the relationship is going to fold out for the life cycle of the implementation project. So, and really beyond, right? So any kind of maintenance support, licensing, whatever it is, it's all going to be governed by the contract that you negotiate on the front end. The ideal scenario is to have a contract that reasonably anticipates everything that can happen during that relationship and spells out a process for dealing with whatever issue happens to arise. That's a tall order, because I don't think anybody can look into a crystal ball and anticipate everything that's going to possibly happen in the future. But with experienced counsel, experienced consultants, people that have been through this a few times, you're going to set yourself up for a pretty good chance of success if you do the front end work by anticipating all the things where this thing can go sideways, have a contractual process for mitigating the likelihood it's going to happen at all, and when it does happen, know exactly what the process is to deal with it when it arises. My goal is not to, and this may sound surprising, it's not to put in place an ironclad contract. And there's one reason for that, really, is that I can do that all day, but no one's going to sign it, right? And especially not an experienced software vendor. Right. They're going to just walk away and say, your expectations are unreasonable. The goal is to put a contract in place that defines the relationship. It makes reasonable concessions on both sides. It doesn't shift the entirety of the risk of the transaction to one side or the other. It kind of balances it out in a reasonable way. And ultimately, you should be, as the business owner, the customer, in a position where something goes wrong. You pull that contract out from your desk drawer and you say, oh, look, on page 7, paragraph 3, we anticipated this would happen, and this is exactly what the vendor's supposed to do. And they're going to give you a hard time and say, no, we don't want to do that. That's not how things work. And you say, no, here's exactly what's going to happen. That's the goal. That's a successful contract process right there. That's the end result that you want to have, ideally.
It's kind of removing that ambiguity, making things predictable, having having those clear parameters or guardrails in place for the overall project.
Yeah, I couldn't have said it better myself. I mean, what you're doing during a contract negotiation, it's really not, from the legal perspective, it's not, I'm not concerned with the price, right? That's what people hire you for. That's what there's other consultants that can say, look, you're not getting a good deal. Attorneys aren't really focused on the financial aspects of the deal. I can kind of tell, just because I've done it a lot of times, if list price doesn't mean anything to me, right? It doesn't mean anything to anybody. You get an 80% discount off list, great. It's not because you negotiated something strongly. It's just list price is illusory. But it really is to put in place a contract that sets you up for success by governing the relationship. Right. You never have as much leverage in that relationship as you do before you sign on the dotted line. And you've got to use that leverage in a way that makes sense for you. And really, it's all about risk mitigation. And you've got to ask the tough questions. You've got to make sure that everything is discussed prior to signing. so that you can see where, how far apart you are. We talk about functionality gaps, but there's gaps in perception and gaps about, expectations, and you want to minimize the likelihood of those coming to bite you in the rear end later. And the only way to do that is through a thorough negotiation process.
Right. Yeah, it makes a lot of sense. So when we think about, you've been doing this a long time and for decades now, and now we're in a new year. 2022 is upon us. A lot of organizations are sort of looking forward to, what are our contracts going to look like? How are we going to negotiate with our vendors? What vendors are we going to bring on board and whatnot? But what are some of the trends you're seeing in the market? What's changed from a contractual or procurement or negotiation perspective, or what is changing? What do you expect to change here in the new year or in the coming years?
One of the things that we continue to see as a focus of contracts is, this whole issue around data security, cybersecurity, data integrity, who's accessing your data. Do you need a DPA, a data processing agreement? And it depends. The compliance with, the new data privacy laws that have been put in place over the last 5 years or so, it's a patchwork quilt, of regulations and laws. I'm just trying to navigate that and figure out, what your issues are and what they aren't, and what your obligations are. It's incredibly challenging. I was on the phone yesterday with an NFL team that's entering into a large ERP transaction, and data privacy about, with respect to the protection of the personally identifiable information of their fans was incredibly important. And, it's trying to put standard DPAs in place with them, understanding what their risks are, how to mitigate those risks, and what the compliance framework is, what's actually applicable to them as a processor or a controller, So
Right.
That's, I think, going to continue to be substantive over the next 12 months and beyond. So you've got to have strategies for understanding, how to mitigate those risks, what your obligations are, and what you can, reasonably hold your vendor's feet to the fire for. The other thing that we're seeing on a pretty consistent basis is vendor inflexibility with respect to negotiation. It just, you try negotiating with Oracle, and it's just, you're getting the stiff arm, every which way. It's just, there's not a lot of flexibility. And I think, it depends certainly on how much money you're spending, what kind of market you're in. I mean, if you're in a strategic market for them, you're a newer customer, they really want to get an inroad into the industry that you're in. Maybe you have more leverage, even though you're not spending as much money, but, always you're spending multi-millions of dollars, things get a lot easier as far as concessions. You're spending, under $1 million, good luck, right? You're not really going to get a lot of concessions for them. One of the other things we see with respect to Oracle in particular is really the push, and it's a continued push to try to finance these lower money deals. And that's almost always a mistake from a customer perspective, because you really take away a lot of flexibility if something goes wrong. If you finance the deal through, Oracle's financing arm, and you want to hold back payments, you don't have the ability to do that necessarily, because there's an acceleration clause in those agreements where everything comes due at once, and they hold that over your head, and it becomes very challenging. Those are some of the trends that we're seeing. I mean, I think, there's more granular things that we can talk about as far as, specific techniques for negotiating, and, indemnity and limitations of liability and super caps and that kind of thing. But from with a broad brush, that's really kind of where I see the market going, or where it has been and where it's going to continue to go.
So why do you think that is that some of the vendors are demonstrating this inflexibility? Is it because of cloud solutions, or more of a cookie cutter-ish sort of deployment or approach, or is it just that you've got bigger vendors now that are more active, or what do you think's driving that?
Well, I think it's kind of both. I mean, I think, they're really incented to get these deals done quickly, right? And a long, drawn out negotiation process doesn't serve that need. They're really going into kind of the SMB space. You look at Oracle with NetSuite, those are smaller deals. And so their desire to negotiate a smaller deal is just gone. And the mantra that they keep repeating is, look, this is a cookie cutter cloud solution. Everybody gets the same thing, and you don't need to negotiate it, because everybody gets the same. Our business model doesn't really support kind of these one-off concessions. And that's not really true. Okay. First of all, everything's negotiable. It just depends, on what kind of leverage you have and how much they care about that customer relationship. But at the same time, it really is something that you've got to deal with, and you've got to have experienced attorneys on your side and experienced consultants that know, what's a reasonable ask right now in this environment. What can you get? What's important. You don't want to spend, time and money negotiating things, negotiating for contingencies that are very unlikely to happen, right? You want to get the most bang for your buck out of your contract negotiation with the goal of mitigating risk. And, if you're only going to get, 5 things, make them count, right?
Right.
So yeah, but to answer your question specifically, because I'm not sure I have, is I think it's the size of the deals, right? It's this cookie cutter approach to these transactions. And, it's leverage. Basically, if you don't have leverage, there's no incentive for them to make any kind of serious concession. Their excuse is, it's a cookie cutter transaction. It's a SaaS transaction. You're in the cloud. It's a single offering to all of our customer base, and there can't be any one-offs. That's the push. But, a lot of that's not really true. So. Right.
Yeah. And just that's really interesting. And just a quick note for turning to the audience here on the live stream, we've got people from all over the world. We've got just a few examples of people joining here from UK, Ukraine, El Salvador, Dubai, Kuwait, among others. So as we're talking here today, I'd be curious to hear from this global audience. Both Marcus and I are based in the United States, but I'd be curious to hear if some of these trends we're talking about are true in your regions, or if there's things that are unique that you're seeing in your region or your part of the world from a legal or contract or just a vendor behavior sort of perspective, because that's a lot of what we'll cover here today. So I guess, one follow-up question there I'll ask then is related to the whole inflexibility thread is, are there certain vendors that you work with or that you negotiate on behalf of or interact with, or negotiate with, I should say? You don't negotiate on behalf of the vendors. Typically, usually it's the customers, I believe, that are hiring you. Is that correct?
It goes both ways, but yeah, It seems about 80% of our business is really focused on customers rather than vendors.
Okay. So when your customers are hiring you to help deal with these contracts, are there certain vendors, and you don't have to necessarily name vendors if you don't want to, specific ones, but are there certain ones that are easier to work with than others, or is it sort of kind of a universal issue that you see across the board with that inflexibility and some of the challenges you've pointed out?
It really is vendor specific. It's not kind of a one size fits all kind of situation, and I'm happy to name them because they frustrate me to no end, right? The most inflexible vendor that I've dealt with in the past 12 months is Microsoft. Okay, it was a large spend. Microsoft essentially told us to pound sand. We spent an inordinate amount of time going back and forth with them. In the end, we were only able to get very few concessions. A lot of time and a lot of money was essentially spent on that negotiation. In the end, they ran it up the flagpole multiple times, and they just weren't willing to move. Again, it was a larger deal, but it was a larger deal kind of in the mid-market, and maybe that's the reason. So I'd say Microsoft is typically less willing to be flexible. Oracle is notoriously difficult. If you are spending a large amount of money with them, they're certainly going to come to the table. But if you're spending anything under $1 million, or even not much more than $1 million, I don't think you're going to have a lot of leverage and a lot of success getting a ton of concessions from them. SAP is generally willing to work with you. They're usually flexible. They're just kind of practical in the way they approach things. Their legal counsel is usually very reasonable. Infor is kind of in between. They're certainly not as bad as Microsoft and Oracle. They're not nearly as flexible as SAP is.
Right. So you mentioned that if you're not spending more than say $1 million on a deal, it's going to be hard to get a lot of attention from some of those vendors that you just mentioned. What about some of the smaller, industry niche or best of breed types of solutions that maybe aren't as big of vendors, but they're, so maybe, in other words, let me rephrase the question. Do you have, as a customer, do you have more leverage in negotiations with a smaller or mid-tier vendor versus one of the big ones, like you mentioned, like SAP, Oracle, Microsoft?
Well, I'll give you the classic lawyer answer, right? It depends. Okay.
Right.
it really depends on the company. It depends on the niche. It depends on the type of solution that you're purchasing. So, if it's a very narrow niche product, single sign-on security or something like that, you may not have that much leverage, and they might be really telling you the truth that you're spending 60 grand on this, and they're not gonna really move on concessions and negotiation. It just doesn't. It eats up into their profit margin too much. They don't want to spend months negotiating something that they're only going to get 100K on, right? But if it's maybe a third tier ERP vendor, they may be more willing, to negotiate with you, because the $1 million that you're spending with them means a lot more to them than it does to SAP, right? So you're a big fish in a small pond, and they're going to do everything they can to get your business. And sometimes you don't know until you kind of get into the negotiation which way it's going to go. But I'd say, kind of general, ERP providers are going to be more flexible than narrow niche providers. So, and the other thing to think about too is services, consulting agreements, MSAs, professional services agreements, whatever you want to call them. Those are always easier to negotiate than the software contracts themselves.
Interesting. Okay. Well, and speaking of that, speaking of SI or sort of non-software contracts, I want to pull a question from the audience, and it's a long question. The entirety of it doesn't show here, but this is from Ghassan on LinkedIn, and he talks about it's a long question. Like I said, it's not mentioned here, but basically he's talking about how he in a previous life or a previous negotiation reached a stalemate with an SI for which country would be used for arbitration. So it's a multinational deployment with an SI with multiple offices. This sounds like this organization had multiple offices. Is that something that when you think about like the venue of a contract or some of these multinational aspects of a contract, is that something you have experience with or have any thoughts on just in general, how to address some of those nuances of a multinational contract like this?
Yeah, it's a tough question because obviously there's a lot of fact-specific information associated with where you're going to want to arbitrate or mediate. Now, the location may not be as important as what law governs. Okay, and in fact, it's not. I mean, if you're in Kuwait versus Saudi Arabia, I mean, if you're kind of geographically close to each other, it's more inconvenient for you to travel, outside your home country to another country. I mean, you're in, Colorado, I'm in Chicago, us having to travel to, Ottawa to for a mediation or an arbitration, that's not much different than, you traveling to New York City or something, arguably, right? Right. But, if it's Canadian law versus U.S. law, that could have a substantive impact on how that the outcome of that dispute. So I think, you've really got to think about, what law you want to govern the dispute. And ideally it should be, in my view, from an American perspective, it should be, the law of your home country, ideally, and the law where the services are being performed that should be kind of what you're aiming for generally in most scenarios, just because you're going to be more familiar with it. It's going to be easier to access attorneys that or that you've got referrals to that are familiar with that type of law. What you don't want to do is, we have a mediation or arbitration in Argentina, and now we're, scrambling to find, Argentinian counsel that's competent, and we've got to fly out there. We're now dealing with law that we're unfamiliar with. That could have serious ramifications. So, ideally, the venue is what we call it, should be where you're located, and ideally it should be your law. I mean, the worst thing that can happen is what we call in the legal world to get home courted, right? You're a foreign corporation, subject to dispute resolution in another country. Everybody there is, the same nationality. You're the odd man out, and now everybody, is glad handing each other and winking at each other, and you're the guy that's getting screwed because you're not from the same country. So those are kind of the practical considerations of it, without knowing the the intricacies of the legal aspects of the jurisdictions.
Yeah, absolutely. And that's a good point. And then a follow up to that, also from Ghassan on LinkedIn, is he was talking about with one ERP vendor he worked with, they couldn't make changes to their annual maintenance contract. And when they tried to change those clauses, the vendor said no. And I know this is something I've heard you speak about it at our events and other presentations I've seen you give. I've heard you talk about the hyperlink that's embedded in a contract that they can change at will, however they see fit, and some of the difficulties negotiating, the maintenance or SLAs in general. What's your experience been along those lines, or what tips might you have for someone who's facing that same problem?
Yeah, I think you're in kind of an uphill battle situation. I mean, the problem is these contracts can be ever expanding, right? You've got a piece of paper that's usually some kind of PDF or a Word document, and then there's all these embedded links that then link to other documents. So the document you think that's 4 pages long is 150 pages long. That's just a nightmare for review and negotiation purposes. And I think the bright line there is really to be aware of and push back on their desire to be able to change agreed upon contractual terms at any point in your relationship with them. Now, because that's unreasonable. Okay, why have a contract, right? There's no reason to have a contract if one side can change it at will. Now, there's a reasonable aspect to this, and what they want to be able to do is change terms and conditions that govern the way you interact with the software to the extent that they've made substantive changes to it, 2, 3, 4 years down the line. Now, that's a reasonable concept, so they've got to have the flexibility to make changes to the software. And if those changes necessitate, a different way that you're going to interact with the software, they should have the ability to modify that. So that's kind of, both sides of the coin there, and you've got to find a middle ground that's reasonable. But certainly one side should not be able to make unilateral changes to a contract without the other side's approval.
Yeah. I find that fascinating that vendors, will pull that, or some of the stiff arming they'll do to try and push through their clauses or their terms or whatever. What about if we kind of flip the other side of the coin, or look to the other side of the spectrum here and look to your experience with organizations throughout the world that have reached some kind of failure? They're at a failure point and they've got some sort of legal dispute with their vendor or vendors. How much of that, in your experience, could have been negotiated better on the front end versus, it's just something that, the SI or the vendor went astray in their contracts?
Well, okay. So if your project's going to fail, it's probably not going to fail for a technology reason. Okay. Now, people are going to be taken aback when I say this, but most likely the software works. It works for somebody. Okay. And it works for any vendor is going to point to, thousands of implementations around the world, and customers that are using their software successfully. So what that suggests then is that, the software contract itself isn't the linchpin in the process, okay, where the software is going to fail because something wasn't negotiated correctly in the software agreement. And when I say software agreement, I mean the license, the on-prem license, the SaaS agreement, and whatever document it is that governs the software. That's not to say that there aren't provisions that are important in that agreement, because there absolutely are, right? I mean, you've got to know what you're licensing. You've got to know how much it costs. You've got to know what you can do with that software, what the parameters of use are. Can you have third parties access it? Can you have third party technology come in and hook into it? All of that stuff is incredibly important. But it doesn't necessarily mitigate the risk of a failure. Okay. Now, if the software was misrepresented and it doesn't do what it's supposed to do, that's a different story, right? That's fraud or negligent representation or something like that. Okay. That's a whole nother issue. But where the mitigation factor really is going to be in two documents, and they're arguably the same document. It's going to be in the MSA, right, the consulting agreement, the implementation agreement, and it's going to be in the statement of work. Okay, so you have to make sure that you account for the people process, right? It's not the technology process that you're contracting for. It's what is going to happen, right? What are the assumptions of the implementation? who is responsible for the integration, the implementation, the configuration of the software? How are they responsible for it? When are things going to happen? And if they don't happen when they're supposed to happen, what is the consequence? What's the user acceptance testing criteria? What are the agreed upon specifications for pieces of functionality, modules, deliverables, whatever you want to call it? And what happens when there's a deviation from the specifications that were agreed upon? How many times do they resubmit it? What happens? They get let's say they get 3 bites at the apple, right? And it still doesn't work. What happens? What do you do as a customer? You get your money back, terminate the contract, sue them. Get another vendor to come in. There's got to be a defined process. That to me is where, the real cost benefit is, right? You're spending a lot of money on a lawyer to negotiate your contract. And if you put it all into the software portion of it, you may not be getting a lot of value back. It's from a risk mitigation perspective, from a failure perspective. You've really got to, make sure that the assumptions and the expectations are all contractually defined in that services agreement, because that's where failures happen, right? You look at we can name, 10 failures that have happened over the last, 10 years. And why did they fail? Well, there were unreasonable expectations. There were, technology gaps, functionality gaps that weren't accounted for. There were things that were unexpected. And if you can think expansively, account for those in your services agreement, figure out how to mitigate them, then you're really giving yourself a dog in the fight, and you're going to do your best, to avoid a ERP implementation failure.
Right. And that's a great segue to a question from the audience here. From Malcolm on LinkedIn, and he asked the question of do companies and boards put enough effort into understanding all the stuff you're talking about, the importance of contracts, the importance of some of the different criteria we've talked about here today, as well as other criteria that you help clients negotiate. Do you think in general companies and boards of those companies and the management teams, do they understand the importance of negotiating the best possible contract and the one that represents your interests, not just the vendor's interests?
I have to say no, they don't. I want to say yes, but I think they pay lip service to it. They know they have to have a contract, okay? And here's why I say they pay lip service to it. You get a mid-sized company that is entering into a multi-million-dollar transaction for an ERP product, okay? And the first time they reach out to an attorney is a month before the deadline for signing that contract. That's not nearly enough time. Just the turn cycle on a document can take a week, right? So you're putting all this pressure on that contract negotiation process and not giving the people enough time to do it properly and expecting, perfect results. It's just, at that point, you've got to pick and choose what's important, what's not important. You're giving up a whole bunch of leverage before you even start. So I think they understand that it's important, but I don't think they understand the process and what it really takes to do it right.
Right.
And one of the other things too that we see, you talk about trends, and I think this is probably happening because of vendors' positions with respect to the inflexibility and the non-negotiability of their contracts. People are wanting to know, well, what's market, and what are the minimal amount of things that we can do going into this contract, because we don't want to ruffle feathers and we don't want to ask for certain things. So they're less likely to negotiate on the front end anyway. And that's somewhat problematic. I think you've got to assess each situation. You've got to go through, list out all the problems with that contract, and then you've got to figure out what's important to you. You can't say, okay, well, we're only going to change 2 things because we know it's not negotiable. Well, okay, well, that's fine, but what about these other 3 things that are more important than that?
Right. Yeah, and it seems like that, if you're an executive and you don't do this often, most organizations, most executives don't negotiate often with software vendors. It seems like it can kind of get lost in the shuffle with, for example, if our organization was going to acquire a bunch of Office 365 licenses, they may not feel the need to negotiate that contract or the SLAs or the terms of that contract as aggressively as they might, some other large capital purchase. But when it comes to ERP or enterprise technology in general, that's quite a bit different, wouldn't you say? Then there's just more risk and there's more nuances of the contract that you need to really tighten up when you compare it to, say, a Office 365 license agreement. Would you agree with that, or are
Oh,
they
no, I
similar?
agree with that 100%. I mean, they're not similar at all, right? I mean, the risk associated with, Outlook and Microsoft Word for your organization, while they're important programs, it's not the spinal cord of your business, right? I mean, the risk profile associated with a failed implementation project, it's just enormous. I mean, if you flip that switch and the software doesn't work, and you can't ship product, you can't invoice customers, you can't even communicate with your customers. I mean, the amount of damage that you can sustain as a company is just enormous, and and that this goes to another issue that you haven't asked me about, but it's if you're spending $3 million, $4 million, $5 million on an ERP system, you've got to make sure that you're spending enough money to negotiate that contract on the front end. I mean, that's not a situation where you want to say, okay, well, we've got enough resources to buy the software, but we really don't have enough resources to negotiate it properly. Let's spend $2,000, just get a high level review of the problem so we know what we're getting into. That might be the way you want to go, but that's not a good move. It's not a sound business decision, right?
Yeah.
I mean, you really want to figure out how to mitigate the risk properly so that it matches what your risk tolerance is.
Yeah. Yeah, I think maybe organizations should think of this sort of contract negotiation less like an Office 365 or some, more simple, relatively simple IT contract, less like that, and maybe compare it more to what you might go through if you're negotiating a capital construction project of a new building. Hiring a contractor to build a building, or if you buy a bunch of equipment for your shop floor, or a bunch of machinery, you're probably going to spend intuitively, you need to spend time negotiating that. It's a big investment, so you want to make sure you get it right. You're reducing your risk, all that stuff. So I would see it more as think of it more as one of those big, complex capital contracts that you might negotiate elsewhere. That's how you should be treating these sorts of contracts as well.
And I think that's a good way to look at it because that's exactly what it is, right? I mean, you're investing in infrastructure to make you more profitable, to make you more efficient. And if you get it wrong, it's going to have far-reaching consequences, negative consequences for the business that are going to be potentially devastating. So it's a critically important contract to review. And the challenge that you've got is, I mean, we live in a world of click-to-accept agreements and apps and that kind of thing. And then when you've got a vendor that says, well, these are digital contracts, DocuSign, just go through it quickly, we'll get this done. That's what the salespeople are trained to do, and that's what they push you for. And you don't want to be one of those unsophisticated individuals that does that. Like I said, you're setting yourself up for failure and a rude awakening down the road if something goes wrong.
Yeah. Now, let's just say I'm an executive or a team member, and I get everything you're saying. I'm buying it. I'm buying what you're saying right now. But the vendor comes to me and says, hey, I've got this really sweet year-end deal or quarter-end or month-end or week-end deal. They always seem to have deals that are once in a lifetime that you've got to sign right now. But what do you do in those cases? Do you see that dynamic at play often where it's sort of like, let's not focus on the attorney stuff that Marcus is talking about. Let's focus on the sweet deal I'm going to give you if you just sign this and agree to all these terms by, the end of the week or the end of the month or whatever. Do you see that dynamic?
All the time. That's the most common dynamic there is, right? And, what I've got to tell my clients is, look, we brought it up a little bit ago. It's okay. You're going to get this huge discount off the list price. It doesn't mean anything. Okay. If that discount's available on December 31st, there's going to be something similar that's going to be available, in January. It may not be the exact mix, but trust me when I tell you that if we properly negotiate this contract, we can lower your spend over the life cycle of that contract in a way that's going to get you more money, save you more resources over the life cycle over time than just on the front end, right? You can't get seduced by the front end discount because it doesn't mean very much. I mean, if I can get you, caps on increases in future license spend, if I can get you, discounts on particular products that you might like, or we can narrow down the definition of, just as an example, of user types, right, or whatever the licensing metric is, so that it's not so broad that they can come back to you and say, oh, well, now you owe us so much money. How much money does that save you, right? Potentially a lot, and potentially a lot more than whatever sweetheart deal they're proposing to you now. So you got to look at it holistically, right? It's not just about a front end discount.
Yeah. Yeah, and I have yet, I don't know if you have the same experience or not, but I have yet to see a vendor that I can recall that has pulled an offer off the table and not honored, sort of a year-end offer. So in other words, December 31st came and went. You hear this last year, they had this deal that ended at the end of the year. Come January 25th or whatever today is, they decide that, the customer decides, yeah, okay, I want to move forward now with that same deal. I've yet to see a vendor that says, no, actually, we're not going to honor that now. If you're ready to buy, chances are they're probably going to they're going to take you up on that, even if it was a, limited time offer of sorts. Have you found that same experience, or have you seen otherwise?
I haven't seen the deal just totally disappear. Okay, where they go back to, oh, well, now you got to renegotiate the whole thing. I haven't seen that happen. Now I've seen kind of a different mix, and maybe not as good of a deal. They couldn't get the same approvals because they're not incented, right? It's like, okay, well, I'm not going to go to President's Club now this year. I'm not making a big bonus, but
Right.
but it's going to be equivalent, right? It may not be the exact thing. So I think the sense of loss or the sense of urgency that they set up, it's really not warranted. I had a deal a couple years ago. It was I won't tell you the vendor, but it was an end of year deal, and we stayed up until 11:30, and we got the deal done, but they couldn't get it signed on their end until the next morning. And so they told us that night, well, the deal's off the table. But of course, magically at noon the next day, the VP comes in and is like, no, we can still honor it. So, even when they say they can't, they still can.
Yeah. Good point. Here's another audience question that's an interesting one that is a really good question that I don't think I've ever asked you in all the times we've talked. But that is, how does the risk increase if you're dealing with more than one software vendor? And thank you, Malcolm, on LinkedIn for asking this question. But if you're dealing with, sort of a best of breed environment, or you've got, third-party bolt-ons or multiple systems that you're deploying as part of your transformation, and therefore you have multiple contracts, how does that risk increase, and how do you treat the negotiation process differently in those cases?
Well, I think the risk is increased dramatically, right? I mean, the more cooks in the kitchen you have, so to speak, the more problems you're going to have. We had a very large SAP failure a few years ago, multi-million-dollar failure. It actually put the company out of business. It was so bad. It was shockingly bad. One of the worst ones I've seen in my career. And they had probably 3 different vendors in there that were, doing bolt-ons, add-ons, niche players to the SAP system. And it was just a nightmare. So when it all hit the fan, where do the fingers point? They pointed at everybody, right? SAP points to this guy points to this guy. That's the problem that that you're dealing with. From a contract perspective, how do you mitigate that risk? I think, you've got to make sure that to the extent that a vendor is using subcontractors or third parties to provide services on its behalf to you, that there's contractual language in there that obligates that vendor to be responsible for any acts or omissions of those subs or third parties as if they were that vendor's own acts or omissions. So, the goal is, as we say, is to have one throat to choke, right? If you can do it. Now, it's not going to work in every scenario because it's just, it may not be a sub scenario, right? But I think you've got to think about the risk profile associated with bringing in multiple vendors versus using one vendor that has that same functionality. It may not be the top tier functionality. It may be a B piece of functionality versus this niche player that's got an A functionality. But think about the risk mitigation associated with it, right? You've got 7 vendors that come in. It becomes way more difficult. If you've got 2 or 3, it becomes easier. So I think you don't want to be short-sighted when you think about how hard it's going to be to manage this process.
In addition to having to think about all these different moving parts with multiple vendors, do you have, who's ultimately in charge contractually? I don't know if that question makes sense, but who's the, everyone's looking for that single throat to choke or that single hand to shake, depending on how you look at it. And when you've got a best of breed environment with 2, 3, 5, or however many software vendors, how do you create that accountability in a way that doesn't just lead to finger pointing later? So in other words, it wasn't my fault that this project went south, it's because of that other vendor that you're trying to integrate with. Their data didn't flow back to my system the way it should have, or whatever. There's a lot of finger pointing that would happen there, or that does happen there in those environments. Is there a way to negotiate around that, or to create parameters in the contractual and procurement phase that protects against that sort of thing?
Yeah, and there is, and really in the statement of work that's associated with the integration or the implementation of the products, you're going to want to lay out, who's actually responsible for, when these additional vendors come in, and who's going to ensure that, that piece of functionality is integrated properly, or that vendor is actually managed right. But you're going to have a push-pull kind of situation, because you as the customer, you're going to do everything you can to get your main vendor to be responsible for all these other vendors. And that vendor is naturally not going to want to be responsible for any acts or omissions of pure third parties that it's not even responsible for. So there's going to be a delicate dance in the way that you structure that contractual framework, but you've got to do it. You've got to figure out, how to give yourself the best opportunity to look to one vendor when everything goes sideways. And it's not an easy thing to do, but yeah, there are techniques, contractual techniques to try to do that. Yeah,
and it also seems like even in situations that it may be a bigger hidden risk contractually is when they're mixed. Vendors don't have real strong HCM or warehouse management sorts of systems, so they'll bring on a partner that they partner with to integrate to a third-party solution. So you feel like you're getting it from one vendor, but in reality, oftentimes what ends up happening is then the finger pointing happens there. So in other words, it's not my fault, it's my partner's fault. And as a customer, you think, well, yeah, but I bought the software from you, expecting you to be able to handle that. Do you see that dynamic often?
Yeah, we see it all. It's pretty common, actually, right? When things start to go sideways, that's exactly what happens. And again, there are methodologies, contractual frameworks for dealing with that scenario, and in some ways, and some of them aren't even directly related to that particular issue. But it could be as simple as identifying all the third parties that are going to touch the software or have access to your proprietary information or confidential information, so that you at least know, right? You can have them sign some kind of acknowledgement that says they're going to be bound by the same terms and conditions. I mean, there's a lot of different ways to go about it. And it's really going to be dependent on the particular scenario and the particular engagement. But it's like you said, it's a hidden risk, and you've got to hire people that have been through this rodeo a few times in order to be able to parse that kind of thing out. Think about it expansively on the front end to mitigate the risk on the back end.
Right. Just wanted to also, this isn't a question, but from McDonald on LinkedIn says, great insights. Good to be here. Greetings. I think McDonald's been on our live streams before. I think he's somewhere in Africa. I forgot which country you're in, McDonald, but thank you for being here from Africa today. So another question I had for you here is, what are some of if we sort of shift gears away from procurement a little bit and just look to sort of the downstream impact of implementations, what do you see changing, if anything, here in the 2020s as far as implementation risk and things that, are things to be aware of or watch out for, potential blind spots, red flags that exist now or emerging or becoming a bigger deal now than perhaps 2 years ago or 5 years ago?
Well, I mean, you can't avoid, the whole COVID situation, right? And what it means to these implementations. I think the likelihood right now, certainly, that you're going to have teams on site doing integration, implementation, configuration of your system is pretty small. It's all going to be done remotely. And when that happens, there's a couple of things that you've got to be aware of. One is you want to make sure that you've got tight provisions that are governing the treatment of your intellectual property, your confidential information, your proprietary information, your personally identifiable information. Because if you've got 10 people that are all working remotely, coming in, burrowing in, accessing your stuff, you want to make sure that there's protocols in place for protecting it. So that's one issue. It's certainly different than I think a couple of years ago. And then the other issue is really, again, a people issue. How do you put in place the proper contractual provisions to manage an entirely remote staff, right? I mean, you've got to make sure that you've accounted for that, that you understand, what percentage of people are going to be accessing remotely, where they're going to be working from. I mean, is everybody going to be working from the Philippines? Are they going to have the right levels of experience? Are you going to be able to replace consultants that are underperforming? All of those kinds of things become more of a management issue as everybody's working remotely, because it's different if they're there and you can see what they're doing. That's one thing, right? But if all these people are working from other countries and they're burrowing into your system, late at night, how do you have any kind of quality control over anything? So all of those things become important.
Also, in addition to that, intellectual property, the security issues, there's also just the transparency into what your vendors are doing, not necessarily just from a security perspective, although that's obviously very important, but also from a cost visibility perspective and a project governance perspective. If you have a system integrator with a bunch of resources that you never see, they're never in your office, but they're off somewhere else billing by the hour and putting X number of man hours into the project, it's even harder now to look behind the curtain to see what exactly these people doing. Do I need all these people billing all this time to my project? It was already a problem before COVID, but now it's even more of a problem, I would say, in this post-COVID world with more remote workers. Would you agree with that, or have you seen that dynamic?
No, we see it all the time, and I mean, you've got to make sure that your steering committee meetings are happening, your weekly project status meetings, whatever, however often they're happening, are actually happening. People are attending those, that you've got your finger on the pulse of what's happening with your project. And one of the other things that we see, and this is in the litigation context, is we'll see regularly updated and provided project status updates, but a lot of times those are, and I've used this word a few times today, illusory, right? I mean, they don't really provide any kind of meaningful information to you to make a decision as to what the real status of the project is. Everything's a green light, everything's great, and then all of a sudden everything turns into red, and you're like, well, what the hell happened here?
Yeah,
right?
How did that happen?
Exactly, and that's when all of the the fundamentals, right, become incredibly important. It's just basic project governance 101 has to come to the forefront in this type of environment. You can't leave anything to chance. And I've got clients, particularly in the litigation context, that say, hey, we want to have a hands-off approach. We're hiring experts so that they can come in and do what they need to do. We are not experts in software implementation or integration, project management. That's why we're hiring people to do it. And that's fine, but you've got the fox guarding the hen house, right? In that the vendors are incented by billing hours and making modifications and customizations to that system so that they can generate more revenue. And so your interests aren't aligned. And if you're not actively managing the project, you're really going to be in for a bad surprise at the end.
Yeah, that's a great point. And so even the best contracts with the best parameters and SLAs and terms and conditions, even though the best contracts, the best negotiated contracts still can't save you from poor project governance or lack of project controls and that sort of thing that oftentimes gets off track. It can help you. I suppose it can help establish some of those more formalized, documented controls, but it's not going to totally save you. You still have to manage the project the way you would, any other big project.
Right. I mean, we can put the obligations in the contract, but if no one's going to abide by the contract anyway, then we can't really it's not really going to be much help, right? I mean, you've got to have someone that's interested in living by that contract. If you put all the effort into developing a contractual framework that lays out all the things that you're supposed to do from a project governance standpoint, that's one thing. But if you don't follow them, then what was the point on the front end?
Right. Here's an interesting long question. I'm going to try and simplify it. In fact, I'm not even going to show it on the screen because it'll show. But this is from Gassan on LinkedIn as well, and it's a really good question. I'm just trying to think of how to paraphrase this, and I don't know if you can see it too, Marcus, but if you can, it might help to read it. But it's the one that starts with another lengthy question that came to mind. As there were deliverables and documentations during the ERP implementation that one could use for knowledge base or refer to in the event of a future dispute, I decided to video record all the training events by the ERP consultants during the design and training stages of the project. This was to be used for future training for new users and any super users who could use it for training material. And then a few years down the line, the company had some issues with the inventory module, reached out to the ERP vendor. They'd reconfigured the module and they had no other choice. He reviewed the recording and noticed that in the design stage, the ERP consultant made the recommendation to configure some parameters of the module. So he had proof of what was actually said or what was being done during that design phase. And I guess maybe I'll broaden the question a little bit or the point a little bit to everything from demos. So you're oftentimes demoed a vanilla off-the-shelf solution, but sometimes that required some special configuration or in some cases customization, or it's a different version of the software than what you're actually getting. So they might demo one product, but then the contract is for an older version or a different version or doesn't match up to what you were shown. Do you have any recommendations like this, like recording demos, recording trainings, or anything like that to help just give you the documentation to kind of the paper trail or the thread, the breadcrumbs of how to connect those dots or those, expose some of those risks or challenges?
Yeah, the more information that you've got, the more documentation that you have as to what was said during these meetings is going to serve you well later, right? Because you can't deny, the undeniable as a vendor, right? If my people came in and they said A, B, and C, and now I'm trying to say, well, they didn't say that,
right?
It becomes very difficult if there's proof, right? But I think you've got to be very careful in the way that you go about this, depending on the jurisdiction. I mean, some jurisdictions require, both parties to consent to recordings. Some jurisdictions don't. So you've got to know, what jurisdiction you're in, and you don't want to just, start recording phone calls without the consent of the other party to the extent it's required, because then, you're going to get yourself into trouble, right? And so you don't want to do that. But I think if you take a step away from those particulars, the fundamentals are get everything you can documented. You've got to know. You've got to have proof of what was said. And one of the problems that we run into, there's all types of evidence, right? There's testimony, there's documents, there's emails, text messages. But it becomes challenging when it's essentially a he said, she said kind of scenario where, I say, well, you demoed this to me and it wasn't what you sold me, but there's no proof of what was actually demoed. No real substantive proof. That becomes hard to prove in court, obviously. So I think, get everything documented as much as you can. You don't want to, be pessimistic and think that people are lying to you or actively trying to defraud you. But, these things happen, and, you might as well set yourself up for success if you're going to have a dispute.
Right. Now, what about, trying to decide, I have a few questions here. I'm trying to prioritize them. Speaking of prioritization, what about the vendor migration to the cloud? So, a lot of vendors are moving their products from on-premise to cloud solutions. A lot more customers are buying cloud solutions now than they were 5, 10, 20 years ago. What are some of the nuances or challenges unique to cloud deployments that people should be aware of?
Well, it's almost like this, unreasonable optimism with respect to the cloud is what I would call it. Okay. Just because something is in the cloud doesn't mean it's better than an on-prem solution. It just doesn't. Right? And point of fact, a lot of these cloud solutions that are being pushed on people today, they're not fully baked. They're not real cloud solutions. They're not built for the cloud from the ground up. They're just, old on-prem systems that have now been modified to work in the cloud. Those kinds of things are going to cause problems, and they're not going to work out very well. And it's hard to know as a customer what you're buying sometimes. But I think caveat emptor is really what should be governing your approach to these things as a customer. And you've got to be asking those questions during the sales process. Is this built for the cloud? How is it configured? Are you just taking something that was an on-prem solution, and modifying it to be a cloud solution? Just because something's in the cloud doesn't mean it's better in any way, shape, or form. And in fact, I think the constant drip of subscription fees and just other types of costs associated with that can make it actually more expensive in the long run, much more expensive. So if someone just is trying to, as a general proposition, telling you, hey, this is a cheaper alternative, or it's a better alternative from a technological standpoint, that's not necessarily the truth. So I personally don't see in the deals that we do that these cloud apps and cloud solutions are all that mature. Some of them are, but a lot of them aren't. I don't know what you see, Eric, in your situation. You probably see a lot more deals from a technology standpoint than I do. So you probably are, have some insight into that as well.
Yeah, I think it's that what you just said is true, especially for the larger vendors who spent billions of dollars in R&D on their on-premise solutions over decades, and now they're trying to move all that seemingly overnight. I'm exaggerating when I say overnight, obviously, but they're very quickly trying to move that all over to the cloud now to kind of beef up their cloud offerings. And it's just there's just a lot of holes in those solutions, especially when you get outside of sort of the core basic ERP stuff like financials, inventory management. When you get outside that basic stuff into like PLM or manufacturing shop floor automation, all that kind of stuff, there's still a lot to be desired there for some of those bigger vendors. But you also have like the NetSuites of the world, Salesforce, Workday, some native cloud solutions that have been in cloud forever, and my comment that I just made doesn't apply to them necessarily because they've always been in the cloud. But it's more those legacy on-premise vendors that are now moving to the cloud. That's where you see more of that risk that you're talking about there.
Yeah, and you just reminded me something. Cloud solutions sometimes have kind of like this latency concept built into them, and not necessarily intentionally, obviously, but you want to make sure, because this has come up in litigation in the recent past with particular vendors, and I'm not going to say who because it's confidential, but we see substantive issues with certain vendors that their processing speeds in the cloud are almost not built for modern commercial needs. Something's taking 15 seconds to process. I mean, imagine that, right? If it's taking 7 seconds, that's cloud at its worst in some ways. So you've got to go into this with open eyes and ask the right questions on the front end, and really kind of separate the wheat from the chaff as far as what these salespeople are telling you.
Right. Yeah. Well, good. Well, there's a lot more we could cover here and dive into, but I think this gives us a good start and kind of an overview of some of the things to think about as it relates to contracts, procurement, and just overall legal strategies for transformations and software deployments. Want to thank you for being here today, Marcus. It was a great discussion as always. And we will, as I mentioned at the start of the discussion, you're going to be a key speaker at our Stratosphere event coming up February 8th through the 10th. And anyone listening here can register at stratosphere2022.com. It's a 3-day event, and even if you're not able to join live, either all or part of it live, if you register, you'll still get the recordings on demand after the fact. So be sure to register if you're interested in either watching it live and or watching it after the fact. Feel free to register, and we've included a link here in the chat, but you can also just go to stratosphere2022.com. So thank you again, everyone, for being here today and all the great questions, the great engagement here on a Tuesday. Marcus, thanks for being here as always.
Yeah, absolutely. I look forward to Stratosphere, and I appreciate your time today. Thank you.
Absolutely. Thanks, everyone. Have a great rest of your day. Again, watch for our Transformation Ground Control podcast that comes out every Wednesday. This interview will get polished up and edited and included in next Wednesday, a week from tomorrow, our podcast that gets released. And you can find that podcast on YouTube, LinkedIn, Twitter, Facebook, and then all the audio podcast platforms too. So if you want to catch this interview again later, or any of our other Transformation Ground Control podcasts that I host, feel free to check it out on any of those platforms. So thank you, everyone, for being here today. Hope you all have a great day, a great week, and we will look forward to seeing you next time. Take care.
Thank you, everybody.